Good afternoon, everybody, and welcome to this webinar titled Damp and Mould, Understanding the Legal Responsibilities of Landlords. The second webinar in this series that we've been running under Damp and Mould Awareness Week. So just to give a bit of overview about this presentation, landlords are under increasing scrutiny to address damp and mould in their properties, with serious legal and reputational risks if they fail to act. This webinar, led by the legal experts at Ashfords, will outline the current framework, recent case law, and implications for landlords and housing providers. This session will provide practical guidance on how to remain compliant, avoid claims, and ensure that tenant health and safety obligations are met. A key focus on AWAB's law, which introduces the new statutory requirements and timelines for investigating and fixing health hazards, will also be focusing on the updated guidance that was issued last Friday. Today I'm joined by our speaker, Amelia Pine, Associate at Ashfords, to give a legal perspective. Amelia is an associate in the property disputes team at Ashfords. The team routinely acts for landlords, including and advising on defects and defending disrepair claims brought by tenants. So I'm going to hand over to Amelia now, and take it away, Amelia. Thank you very much indeed. We will be taking questions at the end of this session, because I'm sure that Amelia's presentation here is going to answer many of your questions as we go through. So we'll take questions at the end, and please put your questions in the Q&A. Thank you very much indeed. Over to you, Amelia.
Thanks very much, Ben. So this webinar, as indicated by Ben, will focus on damp and mould. There's quite a lot to get through today, so it is going to be a bit of a whistle-stop tour. But like Ben said, there's questions at the end, and if you need to contact me after the webinar, if you've got any questions that either we haven't got through or you don't feel comfortable putting in this space, then do feel free to contact me. My email address is on the screen now, and I believe it will come up at the end of the webinar as well, but if anybody needs it, just let me know and I can pop it in as a response, so no problem. So what we're intending to cover today is these key questions. What key legal duties do landlords have in relation to damp and mould? How have recent cases and legislation shaped the legal landscape? What does AWAB's law mean in practice for landlords, and how should they prepare to meet strict deadlines and obligations? What proactive steps can landlords take to remain compliant and demonstrate due diligence? How can landlords balance responsibilities with the challenge of managing aging housing stock? And what are the potential risks, for example, financial, legal, and reputational, of failing to act within the timeframes that are going to be imposed by AWAB's law and other legislation that's already in force at the moment? So first of all, I thought I would touch on what key legal duties do landlords have in relation to damp and mould. So the first one is to ensure that a tenant is reasonably safe from personal injury caused by a relevant defect in the property. To maintain the property in good repair, that's your standard disrepair claim that I'm sure lots of you have had experience in. To ensure the property is fit for human habitation when it is let and remains in that condition throughout the duration of a tenancy. To comply with all relevant environmental protection legislation, so such as statutory nuisance, making sure there's no damp and mould in the property that's prejudicial to health, and to address all health hazards, and that is under the health and safety hazard rating system. So the first legal duty is to ensure that a tenant is reasonably safe from personal injury caused by a relevant defect on the property, and that derives from the Defective Premises Act 1972. So under that, Section 4 imposes an implied duty on a landlord to have care to tenants and others who might be affected by defects in the property. The scope of the duty, so it's when there's a tenancy agreement in place which has a repairing and maintenance obligation, so that could be expressed or it could be implied by Section 11, and that a landlord must take reasonable care that all tenants are reasonably safe from personal injury and or damage caused by a relevant defect within the property, which could amount to damp and mould. The second key legal duty at the moment is the Section 11 claim, so that's an implied duty into the terms of a tenancy agreement. And then in addition to those implied duties, you also need to be mindful of any express obligations set out in the tenancy terms. and conditions, and any tenant handbooks. So the key here is that with these types of claims, that if you had damp and mould reported, the landlord has a reasonable period of time from notice to carry out those remedial works to rectify the defect. That may change with Arab's law coming into play, and it may already be that you don't have reasonable notice period because the property may not be deemed as fit for human habitation, which I'll come on to in a moment. So the relevant provisions for a Section 11 claim, it applies to any lease which is granted or tenancy granted for a term of less than 7 years after the 24th of October 1971. And the key provisions are to keep and repair proper working order the installations in the property for the supply of water, gas, electric and sanitation. So for example, toilets, etc. As well as keeping in proper working order the space heating and water within the property. And then the third key duty derives from Section 1 of the Homes for Fitness for Human Habitation Act 2018, which amended and implemented Section 9A of the Landlord and Tenant Act 1985. So this is an implied term into tenancy agreements that the property will be let in a habitable condition and remain habitable for the duration of the term. So damp and mould, depending how prevalent it is in a property, could render a property as being unfit for human habitation. If that were to happen, then from the date that the damp and mould is identified as being in the property and the property is unfit for human habitation, the landlord could be in breach of their duties from that date. Typically, you'd need an expert surveyor in housing conditions to identify whether the property is likely going to be in a state which is unfit for human habitation. So we'd always recommend getting an early surveyor in to, whether it's in-house or an independent expert, in to look at the property and identify whether there are any conditions which may render the property as being unfit for human habitation, in particular damp and mould. And whilst you can get the works to get the mould cleared away from the property, it's also really important to think about what the cause of the mould is, because it could be that it just appears again 6 months down the line. So it's really important that landlords are taking steps to investigate the cause of any damp and mould in the property. There's also the Housing Act 2004, which we've got the new, I suppose it's not new anymore, but the system for assessing housing conditions. And that is the Housing Health and Safety Rating System. That's often used by surveyors in order to determine the fitness for human habitation of a property. Category 1 hazards are the most severe, and they are the ones that are most likely to render a property unfit for human habitation. And Category 2 are less urgent, but still need to be attended to as soon as possible. And then there's also the duty to comply with all relevant environmental legislation. So that includes your statutory nuisance claims. So if damp and mould is prejudicial to health, it could amount to a statutory nuisance, which the tenants can bring private prosecutions for, and that is dealt with in the magistrates' court rather than the county court. So the first step, if a tenant were to take that route, would be for them to serve a notice pursuant to the Act on the landlord. The landlord's then got 21 days from the date of service of the notice to abate that nuisance. You would hope with damp and mould that they would be able to, at the very least, carry out a mould wash, for example, to be able to abate that nuisance in the first instance. But again, it's about having the resources and the ability to investigate why that damp and mould has occurred within the property. And then there's also one which I think it's important, but it's probably not touched on as much as the other areas that we've just gone through briefly, is the energy efficiency private rented property regulations. So this does relate to private rented homes rather than the social housing properties at the moment. And that is, they must meet a minimum EPC rating of band E unless they're exempt for some reason, so perhaps for a listed building. The regulations don't make specific a reference to damp and mould, and that's probably why they're not as widely recognised as the other standard disrepair provisions that we've touched on. But if a property's EPC rating is relatively low, then that may be a contributing factor towards any damp and mould in the property, which may otherwise occur. So I just wanted to touch on recent case law before we move on to Arab's law as well, as I know lots of us will be eager to touch on that with the changes that are coming in on Monday. But the court are, in my experience, more aware of circumstances surrounding housing disrepair, and they're definitely putting it under more scrutiny. So in a more recent decision, Uden and Islington, a local authority was liable in damages for breach of its repairing obligations for a flat that had been damaged by rising damp. It had a duty to repair the existence of the damp indicated a failure. I know previously there's been a lot of arguments about latent defects, and if it's the design and structure of the building, that it may not amount to a disrepair claim. But I think the way things are going with, for example, the fitness for human habitation, is that even if it is a latent defect, if there is damp in the property, that does need to be remedied. It does fall within the landlord's obligation to inspect it and rectify where necessary. And then we've got Dalton and For Housing Limited, where a tenant claimed damages in specific performance for alleged disrepair, which included damp and mould. The claims came under the Defective Premises Act, the Section 11 claim under the Landlord Tenant Act, and the Section 9A, which is fitness for human habitation. She alleged that structural issues were causing leaks where there were cases of where there was a cause of damp and mould. And then the judge found that any damp and mould would be caused by the tenant's poor humidity management and not any structural disrepair. So whilst the new guidance that's been issued by the government on AWAB's law, which I'll get onto in a moment, does say that any landlord, it's unacceptable to assume that damp and mould has arisen because of a tenant's use of the property, and it needs to be investigated. It does still feel apparent that the court will, where those investigations have taken place and there is evidence, will still make a finding if it's appropriate that the damp and mould has been caused because of the tenant's, for example, use of the property, rather than attributing it to any other defect in the property. So we'll move on to AWAB's law now. So what I'm going to talk about today is what is the legal framework, who's going to be affected, what is it, what is the timeframe for introducing it, what does it mean in practice for landlords, and what do landlords need to do to prepare. So, as many of you will probably know, the primary legislation, so that's what's bringing AWAB's law into force, is the Act. But what's had to happen is regulations have had to be made by the Secretary of State in order to bring that Act into force. So there is a new Section 42 of the Social Housing Regulation Act 2023 has inserted a new Section 10A into the Landlord and Tenant Act 1985, implying a term into all social housing tenancy agreements that they must social landlords must comply with all prescribed requirements set out in secondary legislation. And the secondary legislation is the regulations that I've just referenced, which is the Hazards in Social Housing Prescribed Requirements England Regulations 2025. There has been updated government guidance issued. It is non-statutory and it is guidance and it is under review. So it has recently been updated as recent as Friday. So I would advise you all to have a read of it, as it's very helpful. It does have some examples on scenarios where something may be reported and it's determining whether it falls under AWAB's law or not. It's important to note that at the moment, it will only apply to social housing. It's anticipated that once the Renters' Rights Act comes into force, that there will also be a provision that extends AWAB's law to the private rented sector as well. So it's all social housing occupied under a tenancy let by a registered provider. However, leases under Section 14 of the Landlord and Tenant Act are exempt. So those are leases where the Section 11 implied repairing obligations do not apply, because the lease granted previously to the existing tenant or a former tenant who's still in possession of a property was not a lease to which Section 11 applied. So if you have somebody who's been in the property since, for example, 1970, they've got a lease that doesn't contain the implied, which Section 11 doesn't apply to. When they are granted a new lease and it's granted under Section 14, the AWAB's law will not extend to them because Section 11 doesn't apply either. It also doesn't apply to long leaseholder properties or other owned owner-occupied accommodation, and it won't apply to licenses either, I believe. And housing occupied under a license is exempt as well. So Awaab's law has come about because of tragic circumstances regarding a little boy that unfortunately lived in property which was suffering from damp and mould. So the government have been quite proactive following that very tragic circumstance. And Awaab's law aims to address hazards that are either significant or emergency hazards, are part of buildings or land which social landlords are responsible for, are in the landlord's control to fix, are not caused by tenant damage, and arises from defects, disrepair, or lack of maintenance. So I'm just going to speak about the time frame for Awaab's law because there are different time frames. So from Monday, as in this Monday, the 27th of October, all social landlords will have to address all emergency hazards and all damp and mould hazards that present a significant risk of harm to tenants. It must be within the social landlord's ability to fix the problem, and the defect cannot be mainly attributable to a tenant's breach of covenant. However, the government guidance does make it clear that it's unacceptable for a landlord to assume that the defect, in particular damp and mould, has been caused because the tenant, and it's suspected that any regulator will see sufficient evidence to identify that a social landlord has carried out sufficient investigations to be able to make a decision that the defect, for example, damp and mould, falls outside of Awaab's law because it is a defect that has arisen because of the tenant's breach of any covenant under the terms of the lease or implied duties. So it's really important that social landlords are still investigating damp and mould to identify the cause before any blame is attributed to the tenants. So phase two, so in 2026, the regulations will be extended to include the following hazards where they present a significant risk of harm. So that's excess cold and excess heat, falls associated with baths or stairs, structural collapse and explosions, fire and electrical hazards, and domestic and personal hygiene and food safety. In 2017, the regulations will be extended further to include all the hazards identified under their HHSRS, other than overcrowding, where they present a significant risk of harm. So the current emergency hazards include gas leak, broken boilers, total loss of water supply, electrical hazards such as exposed wiring, significant leaks, broken external doors or windows that present a risk to the home security, and then significant structural defects or disrepair. And then we've also got the damp and mould as well, which must be considered. So what is an emergency hazard? An emergency hazard is one which poses an imminent and significant risk of harm to health and safety of the occupier in a social home. I understand from the recent government that this has also now been expanded to include carbon monoxide as well. So when determining whether a hazard is one which poses an imminent and significant risk of harm, a landlord needs to take into account the makeup of the tenants and their household. It doesn't just depend what the hazard is, it will depend, and you'll see from the government guidance, on who the tenant is and what their personal circumstances are, and even where their property is located. So a hazard on a top floor flat could be a significant or emergency hazard, but if the same hazard was on a bottom floor flat in a building, it may not receive the same rating once it's been investigated. And then what is a significant hazard? A significant hazard is one which poses a significant risk of harm to the health and safety of an occupier of a social home. So again, this does include tenant-specific circumstances when considering whether there is a significant hazard in the property. As it stands at the moment, the significant hazard is where there's a risk of harm associated with the exposure to damp, mould and fungal growth, but this will be expanded in phases 2 and 3 as discussed a moment ago. So emergency hazards at the moment cover a range of hazards. A significant hazard at the moment relates to damp and mould, but it will be expanded on. So In this webinar, I will be predominantly focusing on damp and mould. It is damp and mould awareness week, so I won't be going into too much detail about the other emergency hazards, and this is predominantly focused on damp and mould within a property. So when there is an emergency hazard, what steps does a landlord need to take? So once a potential hazard I should say a landlord becomes aware of potential hazard, they've got 24 hours on becoming aware to complete all relevant safety works. And this period isn't defined by working days. So if a landlord becomes aware at 5 p.m. on a Friday, then the works to make safe that emergency hazard need to be completed by 4 p.m. on the Saturday. It's important to note that these are maximum statutory times, and if landlords can complete the work sooner, then they should. It's also important to consider when is a landlord considered to become aware, because as soon as they're considered to become aware, that clock will start ticking. So this isn't defined within regulations, but the government guidance has been updated to include examples which including is likely to be subjective, discovering a potential hazard during a routine inspection or visit, conducting an investigation into a different or related hazard under AWAB's law, for example, maintenance by staff, being notified by a third party, which can include any contractors, agents, surveyors instructed on behalf of the landlord, being notified or made aware by a regulator or other body. So, for example, that could be private building control, the ombudsman, the building safety regulator, or, for example, fire and rescue authority, a tenant raising an issue affecting their home, or someone raising an issue on their behalf. So landlords need to be aware of what those emergency hazards could be and what they could look like, because if, for example, a tenant makes a report, they might not know that it could be an emergency hazard under AWAB's law, and the onus would be on the landlord to then take steps to investigate and make safe that emergency hazard within 24 hours. One thing of particular note that has been updated in the most recent guidance issued by the government is that environmental monitoring systems, such as those supplied by Aico, which provides risk notifications, do not in themselves mean that a landlord has been made aware of an emergency and or significant hazard. However, it does state that if the data suggests that there is an issue in the property, a landlord should be proactive and carry out an investigation. It seems to me that the government and regulators seem to be welcoming the use of sensors and sees this as a responsible landlord who is being proactive. So I think they don't want to be seen as punishing landlords who are taking these steps to try and deal with issues before they actually reach the stage of being an emergency or significant hazard. So the data that is collected on those environmental monitoring systems is unlikely to be sufficient for a landlord to be classed as becoming aware of an emergency hazard. So going back to the timeframes, if the property cannot be made safe within those 24 hours, then the resident must be offered suitable alternative accommodation until the required safety works are completed. What is considered as being suitable alternative accommodation will depend on the makeup of the residents, any vulnerabilities, any authorised occupants that also occupy the property, because you'll have to decamp them as well for that period of time. And you must also ensure that you're taking into account any particular requests that they have. I know I'm not saying you need to go over and above the property that they've already got, but you have to be mindful and try and work with the tenant to provide alternative suitable accommodation. If you haven't been able to complete the works in the 24 hours and the tenant needs to be decanted to alternative accommodation, then the landlord needs to provide a written summary of the investigations and its findings to the tenant within 3 working days of conclusion. And it says if required, and the reason it says that is because if the works have been completed, then there's not an obligation to provide the written summary. What needs to be included in the written summary includes whether or not the investigation identified a significant or emergency hazard, what that hazard is. If action is required under the regulation, then the summary must set out what the action is, a target time frame for beginning and completing the action, Alternatively, if no action is required, the written summary must specify that there's no action required under the regulations and the reason why there's no action required under the regulations, and information on how to contact the social landlord. So then there's significant hazards. So the timeframes for significant hazards are different to those of emergency hazards. The reason being that they don't require immediate attention like an emergency hazard, but they do still need to be dealt with within statutory prescribed timeframes. So again, it's all about the landlord becoming aware, and the same principles will apply for a significant hazard as it does for an emergency hazard or when a landlord becomes aware. So once the landlord's become aware of a potential significant hazard, it must carry out an investigation within 10 days. This is 10 working days. So the day the landlord becomes aware of a hazard, that is counted as day 0 for the purposes of a significant hazard, and the time frame commences from the following working day. So the investigation within 10 days, that can either be an in-person inspection at the property, or it is permitted for that to be a remote investigation as well. However, it's really important to note that if there is a remote investigation that's conducted rather than somebody physically attending the property, the tenant can request a renewed investigation. So this is an in-person investigation specifically requested by the tenant after an initial inspection has taken place remotely. This must be completed within 10 working days of that request, and essentially it's going to reset the clocks for landlords. However, it's important also to note that a landlord is not under an obligation to carry out the renewed inspection if works have already begun to prevent the hazard. So once you've carried out the initial investigation, you've then got 3 working days to provide a written summary to the tenant of that investigation. That needs to contain the same details as I've just discussed. So, for example, whether a significant hazard has been identified, or whether what works have been conducted, or whether no works are required. Why is that the case? If works are required, then the relevant safety works must begin or take steps to have begun within 5 working days of the investigation. If it's not possible to carry out or start the works within 5 working days, then you must start the works as soon as practical, and in any event within 12 weeks. The reason that this has been acknowledged is because it's appreciated, I believe, that there is sometimes going to be specialist work need to be undertaken, and it's not always possible to get together the resources, so materials, the staff, the contractors, to start those works within 5 working days. So if you're unable to do so, then they need to be started as soon as practically possible, but within 12 weeks. I don't think it's going to be a case of saying, oh, we couldn't get to that in time. These are the reasons why. I think you're going to need evidence of why you've not been able to start the works within those 5 working days and why the 12-week period is warranted. Once the works have commenced, they need to be completed within a reasonable period of time. There is no definition of what that period is, and I suspect in part that could depend on the extent of the significant hazard and whether the initial works carried out have in itself remedied the immediate concern for the defect, and it could just be follow-on works. So that reasonable period of time is subjective. If the property cannot be made safe, then again, landlords need to be prepared to offer suitable alternative accommodation until the significant hazard is fully resolved. So if it's going to take you 6 weeks, you can't make the property safe, sorry, and it's going to take you 6 weeks to resolve the significant hazard, then unfortunately the tenant is going to have to be put in an alternative accommodation for that period. I think that's going to be a difficulty for landlords to have that housing stock available to be able to source suitable alternative accommodation, and it may be that it has to go further afield to look at serviced apartments or hotels, but again, that's expensive and there may not be any available immediately. So I think it's really important that there are policies in place and procedures that landlords are aware of on how to deal with suitable alternative accommodation as well. If actually on investigation, the potential significant hazard turns out to be an emergency hazard, the landlord then needs to follow the process for the emergency hazard. So that will include carrying out the safety works within 24 hours of becoming aware. So again, there's additional points to note. Whether it's a significant or emergency hazard, the prescribed hazard must arise from a defect in the home or the building or part of a building of the social home for which the landlord is responsible, and it cannot be attributable to the tenant's breach of covenant or disrepair, because the landlord is not obliged to repair. Again, I know I keep saying this and I'm repeating myself, but it's really important that if a landlord is determining that the breach of covenant under the lease is attributable to the tenant's behaviour, that there is investigation and evidence of this. It is no good, and the government guidance does state it's unacceptable to simply state that the significant or emergency defect is a result of the tenant's breach of covenant. Irrespective of this, if there is a defect in the property, the landlord is still under an obligation to take steps to remedy that, whether that falls outside Awaab's law or not. So, for example, if there is damp and mould in the property, you're still under an obligation to remedy that damp and mould and make sure that the property is safe for the tenant. So this is a diagram that is included within the government guidance, and it is a walkthrough to help people identify what steps needed to be taken and when. So, for example, you've got the potential significant hazard here in blue, and you've got the potential emergency hazards here in the process that needs to be followed. I would recommend everybody making themselves quite aware with that, because I suspect you're probably going to be referring to it a few times in the initial implementation period as well, as I appreciate it is all new for all of us. So how can landlords prepare for Awaab's law? And this is going to be more practical tips on what landlords can do to try and prepare for what is coming, and what probably a lot of landlords already have a number of disrepair claims, and it's already stretched. The resources are already stretched with those fitness for human habitation claims, and it's adding another layer to all of this. So what can landlords do to be proactive? So first of all, I would suggest that landlords review their policies and procedures that are in place to ensure there's clear protocols for dealing with significant and emergency hazards within the statutory timeframes. So I think that there's two elements to this. This is internal policies, because you need to make sure everybody is singing from the same hymn sheet, everybody in different departments understands what Awaab's law is. Because there's no good somebody in from one department saying, oh, that falls outside my remit, so I can't deal with that, because ultimately it's going to be the landlord, if that's a social housing or eventually a private rented landlord. Particularly in social housing, there's lots of departments, lots of people dealing with different aspects of the property management, tenancy management, for example. So you need to make sure that everybody internally and externally, third parties such as contractors, understand what Awaab's law is doing, and when the investigations for an emergency and or significant hazard are triggered, because there's no point one person in the organisation knowing but not passing that information on, because it is about the landlord becoming aware, not an individual person. So again, I think identify and closely monitor properties, particularly with vulnerable tenants, because the risk of harm with a vulnerable tenant is likely to be higher, and therefore more likely that a significant hazard or emergency hazard is going to be present in their property than somebody who doesn't have the same vulnerabilities. The reason I say that is the significant harm and significant hazards and emergency hazards aren't necessarily dependent on the defect. That does come into it, of course, but damp and mould in a property with children or somebody with respiratory issues already is likely to be more of an issue and more of either a significant or emergency hazard than somebody who is living in a property who doesn't have those vulnerabilities. Again, it will depend on the extent of the damp and mould, but landlords are going to have to think about the individual vulnerabilities of a tenant when assessing whether there's an emergency or significant hazard in a property, as it's not simply down to the defect anymore, it is the makeup of the household as well. And for example, if you've got an emergency hazard, could be a broken window, for example. If that broken window is on a first floor of a flat, that could be a higher vulnerability and therefore an emergency hazard compared to somebody on a bottom floor flat because of the risk of falling. It's also a good idea to carry out regular inspections at properties. I appreciate this can take a lot of manpower, but if a landlord is able to be proactive and schedule regular inspections at properties, then if they identify an issue or a potential issue, then they may be able to resolve it before it's actually materialised into either an emergency or significant hazard, and therefore falls within these really prescriptive time periods. It might be that you go and your surveyor notices a tiny bit of damp and mould, and it could be from a leaking pipe externally or internally. And because they've gone on and had a routine inspection, they've been able to stop that in its tracks before it escalates further and the damp and mould in the property is prevalent and therefore a significant hazard. I think I've touched on this already, but education is going to be really important that staff members and third parties, including contractors, receive training on the implication of Awaab's law and they understand what their obligations are. For example, if a contractor goes to a property to carry out routine maintenance that have been notified, but they become aware or are notified of damp and mould in the property on that inspection, then there needs to be communication and they need to be aware that that needs to be communicated back to the landlord, because under the government guidance, there is a risk that that could be classified as becoming aware for the purposes of either a significant or emergency hazard, and the time frame could start to run from that notification. So it's really important that everybody is educated. It's not just on Awaab's law, but the existing frameworks as well. But I'm conscious that Awaab's law have got the really prescriptive time periods, which are maximum, not minimum time periods that need to be complied with. And again, check that IT and monitoring systems are fit for purpose, that they're user friendly, tenants can access them, there's no issues in them coming online, being able to report something. It might be that you decide you need a dedicated team or line for suspected emergency or significant hazards. But again, I appreciate that's going to take a lot of manpower, but I think a lot of this is going to be practical considerations on how to prevent defects in a home becoming a significant or emergency hazard, and if they do become an emergency or significant hazard, how you're going to be able to deal with them within those timeframes. So what steps can landlords take to remain compliant as well? Sorry, on that last slide, I should also say about the environmental sensors that I touched on earlier as well. I understand that they are becoming more common to be installed in properties and that they can give data to social landlords. So I think it's also about interpreting that data to see whether there's any trends in a particular property or a block of properties. If you've got a block of flats, for example, and they're all kind of giving you the same readings, is also to review that data and think perhaps actually an inspection would be useful to see whether there is something going on before it becomes an emergency or significant hazard. So what steps can landlords take to remain compliant? So again, I think I've already touched on this. Ensure there's a single, clear, comprehensive policy and framework to deal with the hazards, in particular damp and mould. Ensure that the resident reporting system is accessible and efficient. It might be that for vulnerable tenants, you've got a slightly different reporting system, and you need to ensure that they are made aware of that and each tenant knows how to report an issue as well. And also, I think proactively seek feedback on condition of the property through surveys. It might also be that you've got a routine kind of checklist that if you send a contractor out to carry out a routine piece of maintenance or for a specific work that's been reported to the landlord, which doesn't fall within Awaab's law, that actually you've got a bit of a checklist that they take with them and fill out with the tenant. So it asks questions such as, is there damp and mould in your property? If it's yes, say, okay, where is this located? Maybe take a picture of it, attach it to that survey. And then you've got a record keeping of what's happened. And also, rather than having to carry out routine inspections, which I would recommend in any event, you've also got somebody on the ground who is going there to do works. So take advantage of that and get them to almost do a mini inspection and ask the tenant if they've got any issues at the property that that the landlord needs to be made aware of. And then that can be sent back free to the landlord. Again, thoroughly inspect properties at the commencement of tenancies, throughout the duration of the tenancy, and again at the end of tenancies, to ensure that you are dealing with any issues before the property is relet. When it's void, that's probably a good time to carry out investigations and carry out remedial works before it's let again, because you don't then have access issues with trying to get into a property that is tenanted. Again, understand the profiles of your properties. I suspect there are some older properties. So, for example, are there structural issues here that are going to impact the defects that may be prevalent within that property? Are there occupancy factors such as overcrowding, any health conditions, any other vulnerabilities as well, which all need to be considered? So how can landlords demonstrate due diligence? So again, it's keeping a paper trail or data. I know a lot of us now use online systems, and again, it's keeping that data in one place, and for it to be easily accessible and actually easy to understand. I know sometimes the data that can be pulled through, or the paper trail, can be lacking a lot of information, which actually the landlord might have done everything right, but if that information isn't there to support it, it's going to be difficult to evidence that everything has been done as it should be. So we would suggest that everything is in written form, that you interpret data insights as necessary and keep those data insights for at least 6 years, and keep any records for a property for at least 6 years as well. You need to keep investigation reports as well. So if you've got a surveyor who's gone out for you and they say there's no emergency hazard here and there's no significant hazard, then you need a copy of their report. If they don't send it through to you, then you need to keep pursuing them and get that report over, because there's no point in having a telephone conversation with them with nothing to back that up. What you need is evidence of that investigation taking place. The risk, if you don't have that, is that it may be determined that the investigation has not taken place. When it comes to any court proceedings, investigations by the Housing Ombudsman or the regulator. So it's really important that you keep notes of telephone calls, inspections, inspection reports, email trails, as much as you've got. And again, continually review and update policies. I think it's good practice probably to do it at least every 12 months as a minimum. I appreciate that's a lot of paperwork, but I think to keep up to date with the ever-changing sector, which is social housing at the moment, I think it's really important to routinely update your policies, especially if, for example, they're internal policies and your contracts with the contractor have come to an end and you're contracting with a new contractor and they don't know about your policies and procedures in place, and actually the contract you might have with them may have different requirements. So it's really important that you regularly review your policies, but also at trigger points as well. So, for example, the implementation of new law, the implementation of new contracts with third parties, and it's really just keeping everything up to date as much as possible. So then I appreciate you've also got the challenges of managing aging housing stock, so poor efficiency. It might be that actually the tenant is heating and ventilating the property, but because the efficiency of the property, it can't cope with that, and that damp and mould is arising. So it's thinking about what can be done to try and remedy that, whether that's installing a new extractor fan or other ways in which the property can be ventilated. So, it could be that you retrofit homes with upgraded heating systems, modern insulation, double glazing as well. But as I'm sure many of you will know, there's also the flip side to that is oversealing properties and contributing to damp and mould as well. So it's important to think about what we're doing. Is that actually going to cause us more issues? It might rectify the issue we've currently got, but it might actually cause further issues down the line also. So what if a landlord fails to act? what are the consequences under Awab's law. So that the Awab's law does actually make provision for a defence if a landlord has taken all reasonable steps to comply with the requirements, but it's not been possible for reasons which are genuinely beyond their control. So this could, for example, be about unable to gain access to the property. So, you've got a tenant who you've been trying to contact, but they're either agreeing to access and then not giving it to you on the day, or they're simply just not responding to you at all. That could act as a complete defence for failing to act. However, I think there is going to be an expectation that if you can't get access to a property and it's anticipated that there's an emergency or significant hazard, that after you've made attempts to make access, whether that be writing to the tenant, if they've got solicitors involved, writing to their solicitors, calling the tenant, it may also be the expectation that you're applying for access injunctions as well. I have a feeling that these are going to become more prevalent over the next couple of months. The reason being that if tenants aren't giving access and there's an emergency hazard, that is a lot of risk to the landlord, regardless of Awab's law as well. So although they'd have a complete defence for failing to comply, there's further considerations that need to be taken into account. For example, fitness for human habitation, Section 11 claims as well. So I do expect there to be possibly an uptake and more of an expectation for landlords to be applying for injunctions. But obviously, to be successful in obtaining an access injunction, landlords need to be able to evidence that they have tried to get access to the property and have been unsuccessful. So again, that's going to be about your record keeping, ensuring that you've got a paper trail of trying to get access. And again, I think it's regularly requesting access. It's not asking access one day, not getting it, and then not following that up for a month. I think it's going to be about, it's going to be key that it's consistent with the request for access. And also, another defence would be you're unable to source specialist contractors and or materials within the required timeframes. Again, I think this is going to have to be evidenced by a landlord that they have tried and it's not been possible. I think if a landlord can show that they've got it on order or they've got a contractor booked in, but that their availability dictated that they couldn't do it within those timeframes, then I think that would help to build this defence. So it's really important that you keep clear records of all steps that have been taken, whether that's on a management system or whether you've got a document that can be uploaded which notes where those key documents are saved as well. It's really important that those documents are accessible to everybody. So if you fail to act as a landlord, what are the potential risks? And this isn't just about Awab's law, this is about disrepair in general. So non-compliance puts landlords at risk of prosecution. So this could be, for example, through a disrepair claim, somebody seeking damages. I mean, they're going to be able to bring Awab's law into disrepair claims. I suspect we'll probably start to see it pleaded in claims. We start to see them after next week, I'd expect. So it could be damages, so compensation. There could be the legal cost of defending a claim or the tenant's legal costs as well. It could be a fine from a regulator if they notice that there's a trend with a particular landlord, and reputational risks as well. I've got some examples there of people, social housing authorities who've ended up in the news because of disrepair claims. So, reputational risk is very huge. It's a very sensitive subject at the moment, and I think it will continue to be because ultimately people's health are involved with this. You can see below the various news articles that have been published. This is just a snippet, and this won't cover all of them that have been done. But the reputational risk, I think, is going to be quite significant to a landlord as well. The options for the tenant. A tenant can sue a landlord for damages and an implied, express and implied terms. I don't know how many of you have dealt with fitness for human habitation claims, but more recently, county courts have been awarding 100% of the rent paid over the period a property is deemed as being unfit for human habitation, which can amount to significant sums. And, whilst it's in the county court and it's not binding decision, it is very persuasive. And we have found that it's becoming more prominent in decisions being made by judges. You've also got the housing ombudsman, so they will adjudicate on any cases that involved alleged breaches of Awab's law. The law itself doesn't provide for fines to be imposed on social landlords, but the court can award damages and costs on it as well. The social landlords have their own complaints procedure as well, so you might find tenants are using that more as well. And then you've got the regulator of social housing who looks at trends within particular social housing providers and could impose fines if it feels appropriate. That is a whistle-stop tour. I appreciate there's a lot of information there and a lot of repetition, but are there any questions?
Amelia, thank you very much for that very insightful presentation. Though I have a couple of questions that have been put onto the Q&A. First one, is it possible to outline the timeline for AWAB's law in Scotland?
I don't know the answer to that if I am completely honest on this webinar, but I can find out and ask for Aico to distribute that. That's not a problem.
Yep, no worries. And there's a second question come in. Some of it has been answered in your presentation there, but let me just point this out. How to identify if the mould first appeared before or after the tenancy started, and how to identify if the mould is caused by a tenant's negligence, such as hanging wet laundry inside the property and a lack of ventilation. If the mould is not visible on the surface but inside the wall, how can this be proved?
Of course, I'm going to break that down. So first of all, I'm going to answer how to identify if the mould first appeared before or after the tenancy started. I think from a practical perspective, the best way to do that is when one tenancy has finished, when the property is void, you carry out a void inspection. I know this is routinely done with a lot of landlords to identify what works need to be carried out before it's relet. And I think that gives you a snapshot in time of what the property was like before it was relet. And then once the tenant goes into occupation and there's then mould, you will then know that started after the commencement of the tenancy. I think that's the best way to do it. And again, I think it's looking at record keeping as well, because if you haven't had the benefit of carrying out that void inspection before the new tenant goes into occupation, is possibly looking back at previous records for the old tenant. I know you can't disclose them GDPR, but seeing if there's a trend in notifications for mould in the property from the previous tenant and the current tenant as well. And if you've got any environmental sensors, they've been in situ before the new tenancy, and they've been sending data insights through. I think again that should help you identify whether there was likely to be an issue prior. Obviously, they can't tell you if there's mould in the property, but the data insights can give an indication, I understand. So it can hopefully help you identify whether the mould was in or there was environmental factors inside the property that may contribute to mould prior to the tenancy. It's going to be, I think the key thing here is inspections in the void period before the tenant goes into occupation. In terms of identifying the cause of the mould, I think that's going to come down to investigations carried out by relevant qualified individuals. So I think the starting point is always to get an expert and get their opinion on it. And if they say that they think it is, for example, that a new extractor fan needs to be installed, then if you've then done that work and actually that hasn't rectified the issue, it might be getting somebody else back, it might be getting the surveyor back in, getting another specialist in to investigate and see whether they've got any recommendations for works. And then it could be trial and error, I'm afraid. But sometimes we find when experts go in, they identify that there is washing being dried on the radiator, and they identify that the almost the way the mould is within the property and the way where it's concentrated to within the property, that is likely to be hanging wet laundry inside. But I think with AWAB's law, there's going to be more of an obligation on landlords to carry out relevant investigations. So I think even if an expert says that's like the likely cause, if there is possibly something else in that report which could be a contributor to mould, I think the landlord's going to be expected to investigate that and carry out those remedial works before it can attribute the blame to the tenant's breach of covenant within the tenancy.
That's great and very well put. Thank you very much. We've talked about Scotland. What about timescales for Wales? Any news on that one?
I will double check that as well. I believe it may be similar to the UK, but I will, as in England, but I will double check that as well.
Okay. Well, that's the end of the questions. Just to mention that the presentation will be available. I believe, according to our marketing department, it's going to be put up on our website, I understand, for you to download. The session was also recorded. So, Amelia, it's for me to say thank you very much indeed for a fantastic presentation, and thank you to all of our guests that have joined the session. I hope you found that informative. Um, and hope you are and your teams are prepared for the weeks, months, and years ahead, because this is a significant change in how we are going to be managing and maintaining our properties. Thank you very much indeed, everyone.